Today on Bench Briefs, we're looking at a recent Supreme Court of Canada decision that tackles the tricky balance between public safety and individual rights. R.V. Hilbach. This case dives into when and how police can demand a breathalyzer test without a warrant and what that means for Canadians' charter rights. So, what happened here? Hilbach was charged with impaired driving causing death, a very serious offense. And at the roadside, police demanded that he provide a breath sample using a breathalyzer device. But here's the catch: they did so without a warrant. Hilbach challenged this demand, arguing that it violated his right under Section 8 of the Canadian Charter of Rights and Freedoms, which protects against unreasonable search and seizure. Section 8 is a cornerstone of Canadian law, designed to protect citizens from intrusive or unjustified government searches. The question was whether demanding a breath sample at the roadside without first getting a warrant counts as an unreasonable search under the Charter. If it does, then the evidence obtained might have to be excluded under Section 24(2) of the Charter, which says courts should exclude evidence obtained through Charter violations, if admitting it would bring the administration of justice into disrepute. At first glance, you might think that breathalyzer tests are routine and necessary for road safety. After all, impaired driving is a leading cause of fatal accidents. But the legal issue here is more nuanced. It's about the limits of police powers and protecting individual privacy and bodily integrity. The Supreme Court had to consider whether the breath sample demand was a search or seizure in the legal sense. They also had to weigh the government's interest in preventing impaired driving against Hilbach's constitutional rights. Importantly, they examined whether existing laws and procedures provide adequate safeguards to justify warrantless breath tests. In their decision, the court confirmed that demanding a breath sample is indeed a search under Section 8 because it involves taking something from the body, something inherently personal and private. However, the court also recognized the serious public safety concerns posed by impaired driving and acknowledged that the law permits certain warrantless searches in specific circumstances to address urgent risks. The key takeaway is that the Supreme Court upheld the constitutionality of warrantless roadside breathalyzer demands, but with important caveats. The court emphasized that these demands must be authorized by law and conducted in a way that minimally infringes on individual rights. They also highlighted the need for clear legal frameworks and safeguards to prevent abuse. Why does this case matter? It clarifies the scope of police powers in impaired driving investigations and reinforces the principle that individual rights cannot be ignored, even in the name of public safety. It also sets a precedent for how courts will approach similar cases involving warrantless searches and the Charter's protection against unreasonable search and seizure. For everyday Canadians, this decision helps define the boundary between lawful police conduct and privacy rights during roadside checks. It reassures that while police have tools to keep roads safe, those tools come with constitutional limits. At the same time, it strengthens the legal foundation for enforcing impaired driving laws, which ultimately protects everyone on the road. Thanks for listening to this episode of Bench Briefs. Join us next time as we break down another important legal decision shaping Canadian law and society. Until then, take care and stay informed.